Hello, everyone, and welcome to today's webinar on trust services for cross-border paperless trade. We are thrilled that you joined us as we are delving into the really important and topical issue. This webinar is organized by ESCAP in partnership with ICC, ADB, World Customs Organization, with the goal of fostering collaboration and dialogue around the key issues related to cross-border paperless trade. Today, we focus on trust services. It's a crucial element for enabling secure and legally recognized electronic transactions across border. Before we proceed, let me remind you that the session will be conducted in English, but translation into Russian is available. You can switch the channel and to listen to the translation in Russian. There will be also one presentation in Russian, so you need to change the channels to English. You're also encouraged to post questions in the chat, and I will address them during the Q&A session. Now, let me introduce Ms. Pamela Ma, Managing Director of Digital Standard Initiative at the ICC. She will give the welcome remarks. Thank you, Pamela. The floor is yours.
Thank you, Alexei. And hello, everyone. Delighted to be here. For the Digital Standards Initiative, we consider basically the issue of trust to be a critical one that needs to be addressed on the road to digital trade. And why is that? So trust services actually, they address the need of parties to be able to trust the data that they receive and to also handle the data that they send out in a trusted manner, using technology in order to correctly tag, verify, and authenticate the data. And so building the modular ecosystem, modular because different trust services provide different aspects of trust, and different technologies provide the different elements of verification, authenticity, and security. So it's basically a modular approach that enterprises must take, and these modular pieces need to interconnect. And so we believe that actually an appropriate understanding of the issue is not common in the market, because we have been dealing with lack of trust through documentary checking for many, many years, and the habits are well developed. We all know about them. We all grown about them and the time that they take. But given the advance of technology, it is possible to chart a new way forward with secure data, authenticated data, and traceability, which at the end of the chain is fully auditable. So this webinar basically brings together different kinds of approaches. And I would encourage you to basically keep an open mind as to whether this is actually possible in a nearer term than we would assume. So thanks very much to everyone who's going to contribute to this. And I'd like to just turn it over to the first panelist to get started. Thanks a lot.
Thank you, Pamela. Thank you for your inspiring introduction. Let's now move to our first speaker. It is Mr. Vicente Andrew Navarro from DG Connect at the European Commission, who will discuss eIDAS 2 regulation and its implication for trust services in the European Union, and which is important, and beyond of the European Union. Mr. Navarro, over to you.
Thank you very much for inviting me to this event. I hope you can hear me well, yes, because I have had some problems.
We can hear you good.
Okay, allow me to share my screen, and I'll start the short presentation. Okay, I hope you can see my screen now.
It's clear.
Mm-hmm. Okay, as you may be aware of, in 2024, a new digital identity framework has been adopted in the EU. It has followed a period of discussions, negotiation of more than 2 years in order to amend the existing EIDAS regulation that had, in which some shortcomings had been identified. This new regulation, what we call the new European Digital Identity Framework, includes, as the previous one, 2 aspects, the one of digital identity and the one of trust services, in which I'm going to put the focus. But first, let me allow to present a bit, or to introduce a bit, why the European Commission has created this new framework. With this new framework, what the EU wants is to ensure the acceptance of qualified trust services in the EU and in a cross-border environment, so that trust services can be provided in one country using the other, and that with full transparency and completely straightforward way. And the other part is to provide highly secure and trustworthy electronic identity solutions that are based on a new element. It's introduced by the new framework, that is the EU Digital Identity Wallet. The Digital Identity Wallet will carry identity data from the citizens in a secure and privacy-respecting way that will allow to access both public and private services. The 3 main pillars of the new European Digital Identity Framework are, of course, the EU Digital Identity Wallets that I mentioned before. Member states will offer at least one wallet to citizens that are not obliged to use them, but can use them in order to access public and private services, as I mentioned before. But all these wallets will be built to a common set of standards and specifications and must be interoperable among them. This is in the current framework. Now, currently, we are developing the standards in the implementing act so that can be a reality in less than 2 years. Around the wallets, we have the EID schemes provided to EU member states, to citizens, but we have also the trust services. And trust services refer, as you know, to a range of electronic services that are designed to provide a secure exchange of information between citizens, or between citizens and business, and between citizens and public bodies. For the building of the new framework, we have these main pillars that you have in your screen. We are currently building the legal governance. The regulation is adopted. We are building the specification in the implementing act, the secondary regulation that is being adopted from now until mid-2025. We have also the technical pillar with standardization and harmonization of all the components, requirements, especially of the architecture and reference framework of this wallet. We are testing the wallet in production in a variety of use cases, real-life use cases, through large-scale pilots. And one main aspect of this testing is the integration of trust services. Trust services are a core element of the new framework. They will be integrated in the wallet if that is the desire of the user of the wallet, but they can be used, as it has happened until today, outside of the wallet. So an important part of the framework is the integration of trust services, not only the existing ones. I will go back to that later. There are new trust services that have been introduced in the new framework. In what regards international aspects of the new framework, we are. This is just to give a broad picture of what we are doing in parallel with the development of the new framework. We have a strategic partnership with some countries through association agreements, for instance, the Trade and Technology Councils, the digital partnerships, the association agreements that we have with some countries. We continually have dialogues and information exchanges with countries all over the world. The EU wants to share our model and wants that is used as much as possible, all our developments are made available publicly, and are the software, for instance, the prototype of the wallet is published open source, as so are the technical specifications. We develop pilot projects and proof of concept with other countries outside of the EU, and an important part for this meeting is that we want to advance towards mutual recognition of trust services that we consider is a very important element of the future of business and government relationship around the world. What I am going to focus now in this presentation in the trust services in an international scenario. First, I will introduce you the trust services that were already existing. Probably you will have in your mind the general trust services that exist in the previous EU digital, in the previous EIDA regulation: electronic signatures, electronic seals, electronic time stamps, exchange of electronic documents, systems for the registered delivery of documents, certificate for website authentication, and the devices that allow to create seals and electronic signatures. Those are the traditional ones, the ones that we already had in our previous regulation. What's new? What the new EU DI framework has introduced? Other additional trust services, such as electronic archiving of documents. A very important one that we have put a lot of expectation on it, that is the electronic attestation of attributes, a set of attributes related to a person that can be attested in an electronic way and can be either stored in the wallet, that is the core element of this new framework, but can also be used outside of the wallet, and some additional trust services that we will see how is the evolution in the future, such as electronic ledgers. Another important one is the management of remote qualified signature creation device. As you know, qualified trust services in the EU means those that are that have the highest level of trust in them. A new trust service is the management of devices that allow for the creation of electronic signatures remotely, qualified electronic signatures remotely. And the same thing for seals. What is the landscape in international cooperation around the trust services in the EU? Mutual recognition of qualified trust services under the new framework is always based on the equivalence between the trust services that are provided outside the EU and the qualified ones that are provided in the EU. When this equivalence is proven, then the Union can adopt via legal instruments a decision for recognizing that equivalence and making possible that those trust services provided outside of the EU can use in the EU under the same conditions that those provided in the EU. The instruments that we had until the new framework were the only instrument we had at our disposal until the new framework was adopted was the international agreement, that it's a cumbersome procedure that involves lots of agents or participants in the Union, the Council, the Parliament, even the Court of Justice. If some member states do not agree with that decision of the Commission, and the new framework makes this possibility more straightforward. Once, I repeat, the equivalence is set, the Commission will be able to adopt an implementing act recognizing that equivalence. So the process will become much more straightforward than it was. I repeat, this is only valid for mutual recognition of qualified trust services, those that have the highest reliability, the highest level of confidence. For non-qualified trust services, we are looking also to some solutions that allow us to tackle international cooperation, to accept trust services coming from the countries in the EU and make ours available to others. For this, we have designed a solution focused on electronic signatures and seals, not in other trust services, that is EIDAS compliant, and that allows to member states the validation of electronic signatures coming from outside the EU as advanced in the EU, not qualified. They don't have the same level of trust, but they cannot be denied legal effect. This new tool that we call you will see it in my next slide, we call the third country trusted list, does not impose obligations to member states beyond what was already stated in the EIDAS regulation. But allows us also to interact at technical level with technical partners from other countries in order to align our electronic signature framework and make them compatible and interoperable. So the EU third countries advanced electronic signature trusted list is a tool that does not need establishment of an international signature of an international agreement. Mostly it comprises an assessment of the equivalence of electronic signatures coming from third countries to those to advanced electronic signatures used in the EU. There is no legal instrument for that. It's just a technical assessment, and it's a very straightforward procedure that is basically based on a request from the third country or agreed work plan based on other agreements that the EU has established with other third countries. It's followed by a technical assessment, and with the legal and technical details are assessed in order to ensure that they meet the same legal and technical, that they meet the same standards that those in the EU. And basically, it's a very simple process that means that at technical level, pointers to third countries trusted list are included in this list. Like that makes possible that EU member states or any entities in EU member states can validate these signatures coming from abroad. Of course, this is we are also when we discuss this with the countries, we are telling them, okay, this is a limited step towards mutual recognition, but is a first step that allows us to start working at technical level for mutual recognition of qualified electronic signatures and seals in the future. That it's a more important step. But at least this tool facilitates the use of electronic signatures coming from abroad. This is an example of how this works. The third country trusted list now contains a pointer to Ukraine, and we are working on with Egypt and Moldova, the Western Balkan countries, in order to add them as soon as possible to the third country trusted list. But we believe that this is a tool that can at least pave the way towards the establishment of a general trust framework between the EU and third countries, but will contribute to building a trust framework around the world for the validation of at least electronic signatures and seals, and we will see in the future if we are able to build on top of this other trust services that may be interesting, at the validation of electronic attestation of attributes, or the establishment of global electronic registered delivery services, for instance, that would be a very interesting application of trust services. And that's all from my side as an introduction. Okay, so I will stop sharing the screen and allow you.
Thank you very much, Mr. Navarro. Actually, it was really interesting to see how you have expanded the number of trust services within this new regulation. And I see that there are much more flexibility now to recognize electronic signature from outside of EU. And I believe that it will take time for you to expand this schema for other countries. And there are good examples of Ukraine and also negotiation with Egypt, as you said, and Moldova. It's a kind of a good example for the future development. And I feel that European Union also inspires other countries in the world. And I think we will have a discussion today around the EU approaches in the context of Japan experience, and let's continue to discuss this topic, because it's extremely interesting how you will recognize electronic document from outside of EU, and what is the direction for European Commission about that. I still have a question: who will do this technical assessment? If it's European Union Commission, or it will be trusted services which are already in the trusted list. Thank you very much again. Next, we have Mr. Igor Furgil. He's the head of the certification body in Germany, and he's an expert of UNC Trial Working Group 4. He's a delegate in this group. Mr. Furgil will share insight on trust services in practice, drawing from European Union member experience. And also, I have a quite a challenging question to Dr. Furgil. How do legal, organizational, and technical framework conditions interplay to establish the ecosystem necessary for seamless use and mutual recognition of identification and trust services? Please, over to you, Dr. Furgil, with this challenging question.
Thank you very much, Mr. Bondarenko, for your introduction. Dear participants, colleagues, and friends, good to see you. Thank you for your invitation to this workshop. I would like to give some insights into the topic from the perspective of EU member states, because of the transparency of the EU internal market and the effect of EIDAS as a related EU regulation for electronic identification and trust services. The respective constellation is quite similar in all EU member states. So I will now show to you a couple of slides. So the first question is for what? Why electronic identification and trust services? It's because of globalization across around the world. We have supplier and consumers which don't know each other. It's not the bakery at the corner. And finally, consumers are interested in genuinity of goods and services and documents, and suppliers are interested in correct payments and documents. So, and both of them are interested in a legal virtue of records and documents. And the question is how to provide an evidence, a legal valid evidence of this legal virtue of validity of records and documents. And the establishing of such a trust infrastructure is the answer to the question. Trust services for electronic transactions, they focus on providing legal validity of records and documents, and more generally in validity of electronic data interchange. And our experience, I would say, for the last 25 years, so it means for the period even before EIDAS was established in the European Union, that this ecosystem for mutual trust has exactly three layers: the legal layer, organizational layer, and technical layer. It's a necessary prerequisite. So in the European Union, because of the experience and the development, we have the EIDAS as a EU regulation, and the benefit of regulation as a legal form is that the regulation has a direct legal force in each member state of the EU. So, and by this, it facilitates very much harmonization. And the EIDAS regulation was adopted first in 2016, I think, and in May of this year it was novelled by by another regulation. So we have now what we called EIDAS 2, and it still comprise such aspects as electronic identification, trust services, as a trust service provider, trust services they provide, and the bodies supervising auditing trust service providers. It's probably a partial answer to your question, Mr. Bondarenko. Who shall determine the equivalence of the quality of the services? It's probably the bodies, conformity assessment bodies performing audit of trust service providers. So, and the big benefit, another benefit, of course, is that this regulation ensure the free circulation of these trust services and electronic identification in the EU internal market. So the trust services in scope, we don't need to stay here long. They were already showed by my colleague from the European Union. And so the regulation finally established legal, procedural, and technical provisions on electronic trust services and identifications in the EU. Now I would concentrate on trust services. The legal aspect, as I already said, the regulation has a direct legal force. It's very important for harmonization of all the aspects and regulate the European Digital Identity Wallet and EID schemes. With respect to and the trust services, the procedural aspects are there are non-qualified and qualified trust services with different requirements on liability and different requirements on what a trust service provider shall finally implement and bring evidence about this implementation, and different rules on the supervision of trust service providers. So all trust service providers are put on the list, on the trust service status list, which is a public document. Now some concrete organizational, the procedural aspects here, how the scheme works. We start here, I would short explain it. We start here with the green rectangle qualified trust service provider. They are obliged to perform conformity assessment. So it means not they perform, they will be conformity assessed. It means they have to apply for conformity assessment at an accredited conformity assessment body. And this conformity assessment body verifies documentation and real implementation of the qualified trust services as provided by this trust service provider. Then the conformity assessment body creates a conformity assessment report, and publicly available certificate if the verification was positive, this conformity assessment was positive. The report is provided to national supervisory body, which determine if the report was created according to all the rules, applicable rules. If yes, then the national supervisory body assigns or grants the status qualified to the trust service provider. By this trust service provider becomes a qualified one, and then the electronic identity of this trust service provider, for example, the service public key or service certificate issued by this trust service provider, are published on the trusted list, and this trusted list is compiled to the European trusted list, so it's publicly visible who is a qualified trust service provider and for which service. Shortly, the assessment criteria, it's IDAS itself and different ETSI standards and specifications. We can see it here, and the accreditation I mentioned, that conformity assessment body shall be accredited. This accreditation happens according to ISO EX 70065 and the respective ETSI standards 319403 by the national accreditation body. So it means the conformity assessment body are accredited. It means their ability to perform such audits is confirmed. They audit they audit trust service provider. The report is verified by supervisory bodies, and they grant then the status qualified and put this trust service provider on the trusted list. So the technical aspect, very shortly, it is a good practically all the single articles and provisions of EIDAS regulation refer to ETSI norms and specifications. It's the technical standards ensuring interoperability of all these trust services and also identification means. It's quite important to have a seamless technical interoperability as well, of course, and it is made by standardization, by making standards obligatory, not on a mandatory, not optional. So I would shortly show to you the how this trusted service list publicly available on the internet looks like. It's sorted according to countries. For example, if I choose here Germany, so then for we receive then the list of all trust service provider registered, qualified trust service providers registered in Germany, and we see close to the name of the trust service provider also the trust services provided by this trust service provider. For example, what should I take here? This one, Signate GmbH. This trust service provider provides issues qualified certificates for electronic signature and qualified certificates for electronic seals. Or One and One Dmail GmbH is a trust service provider for qualified electronic register delivery service, etc. pp. So we can see for each country which trust service providers, qualified trust service provider, are active there. Another interesting thing there is
sorry, Dr. Furgel, just
yes,
1 minute to wrap up.
Time is running out. It's more or less the last one of the last before last. So here you can see statistic over all the European countries, how many different trust services or the trust service providers share their trust services here. You can see as a lot of qualified timestamping, etc., PP, or qualified certificates for issuing of signature. The last slide here, how to do bridging diversity by trust, not overcoming but not eliminating diversity between different trust domains or legal domains by trust relationships, and the legal validity of electronic data under different jurisdiction shall be maintained by harmonization. And our experience in the European Union is of very general nature. It is applicable not only for the European Union, but from our experience in any other domains, legal domains, or set of legal domains over the entire earth. Thank you very much.
Thank you, Dr. Fogel. It was really interesting to hear the practical example. And when we have discussed your contribution in advance, you also shared some interesting use cases within the EU, because EIDAS regulation are in place like more than 10 years already. And you told me that it's already working, right? So our participants already asked in the chat, and what are the practical example of this? Probably when we will have a discussion, you can share some practical example. And I believe that you are the head of the certification body. It's yellow
yes,
in your picture, right? So you have accredited
yes, exactly.
several agencies within Germany, right? To
Yes.
make them allow to them to issue certificates. And it's interesting for me also how this qualified trusted provider services, they are having exchange between each other. Do they have any connection between each other to validate the certificate and to have information exchange? And what are the standards they are using for having this exchange? But we can do this afterwards. I think
Okay.
we have a time for discussion. Without further ado, I would like to move to the next speaker, Mr. Yuri Kharakhordin. He is the chief of the IT division at the Eurasian Economic Commission, and he will discuss the development of transboundary trust environment within the Eurasian Economic Union. Please note that the presentation will be delivered in Russian. Please switch the language channel into English. Yuri, could you please pay attention to the necessary architecture for the Trusted Services Framework, which is adopted by the Eurasian Economic Union member states? And can you please explain why trusted third parties, TTP, are playing such an important role? Would it be possible to create a model without them? If not, why is that? Thank you, Yuri, that you're with us. The floor is yours.
Здравствуйте, уважаемые участники вебинара. Позвольте мне вывести презентацию. Надеюсь, презентация видна. Сейчас я веду ее в полноэкранный режим. Коллеги, собственно, моя презентация посвящена развитию трансграничного пространства доверия в Евразийском экономическом союзе. В соответствии с договором о Евразийском экономическом союзе определено, что трансграничным пространством доверия является совокупность правовых, организационных и технических условий, согласованных государствами-членами с целью обеспечения доверия при межгосударственном обмене данными и электронными документами. Одним из основных элементов трансграничного пространства доверия является доверенная третья сторона. Организация, наделенная правом осуществлять деятельность по проверке электронной цифровой подписи в электронных документах. Собственно, меня попросили прежде всего выяснить, почему страны Евразийского экономического союза решили, что для проверки электронной цифровой подписи нужна именно доверенная третья сторона. В соответствии с методическими рекомендациями по использованию и управлению сервисами доверенной третьей стороны Международного союза электросвязи, Recommendation X842, А доверенная третья сторона является также организацией или ее агентом, предоставляющей один или более сервисов в области безопасности, которому доверяют другие объекты, как поставщику данных услуг. Доверенная третья сторона применяется для предоставления дополнительных сервисов организациям либо частным лицам, стремящимся повысить уровень доверия и конфиденциальности получаемых услуг, обеспечить защищенную связь с партнерами по бизнесу, а также возможность подготовки, доставки и хранения требуемых свидетельств, позволяющих восстановить ход событий. Проанализировав перечень доверенных сервисов, указанных в методических рекомендациях, страны Евразийского экономического союза пришли к заключению, что они однозначно нужны для обеспечения безопасного взаимодействия. Также одной из причин явилось то, что большинство стран Евразийского экономического союза не пошли по пути множества других стран по использованию криптографического стандарта RSA и, например, того же криптопровайдера Microsoft. Все дело в том, что страны хотят быть уверенными, что их электронные цифровые подписи достаточно стойкие и не могут быть подделаны или заблокированы. Алгоритм RSA является американским, собственно, как и криптопровайдер Microsoft, доступ к исходным кодам которого запрещен. Поэтому страны Евразийского экономического союза справедливо решили, что более безопасно иметь собственный криптографический стандарт и криптопровайдер, который может быть проверен национальными спецслужбами на соответствие требованиям безопасности и поэтому не иметь черных ходов, backdoors и других уязвимостей. Является ли это паранойей или нет, каждая страна решает сама. Но учитывая, например, те же разоблачения Эдварда Сноудена, действия вируса Stuxnet и, конечно, недавний глобальный сбой Microsoft, затронувший очень многие страны и разные сферы, это, возможно, не так уж и беспочвенно. Я хотел бы отметить, что страны, полностью полагающиеся на разработки других, в долгосрочной перспективе подпадают под внешнюю зависимость и имеют высокие риски компрометации своих электронных цифровых подписей и, соответственно, масштабного сбоя систем на национальном уровне. При этом в мире не так много стран, имеющих собственные национальные криптографические стандарты и криптопровайдеры, так как для этого необходимо иметь собственную многолетнюю криптографическую школу. Например, в Евразийском экономическом союзе это есть в Беларуси, Казахстане, России, а за его пределами у Франции и Китая. В этой связи я мог бы порекомендовать странам, у которых нет возможности разработать свой криптографический стандарт, при использовании того же алгоритма RSA озадачиться разработкой собственного криптопровайдера, так как уже это существенно снизит вышеуказанный риск. Итак, именно для решения вопросов, в том числе для решения вопросов совместимости разных криптографических стандартов и безопасности при трансграничном взаимодействии нужна доверенная третья сторона. На текущий момент страны Евразийского экономического союза уже разработали доверенные третьи стороны для обеспечения трансграничного информационного обмена с использованием национальных электронных цифровых подписей между государственными органами, так называемое взаимодействие G2G. Требования к данным доверенным третьим сторонам согласованы органами в сфере защиты информации всех государств-членов Евразийского союза. Собственно, на данном слайде более подробно представлен процесс взаимодействия G2G, когда, соответственно, отправитель отправляет получателю электронный документ, и он проходит по всей цепочке. Также эти самые доверенные третьи стороны уже модернизированы для взаимного признания национальных электронных цифровых подписей при взаимодействии бизнеса с государственными органами B2G. Речь идет именно о трансграничном взаимодействии, и вы на слайде можете видеть, соответственно, данный процесс. Для регулирования вопросов в рамках трансграничного пространства доверия Евразийского экономического союза принято уже более 30 нормативных и технических актов, некоторые из которых представлены на слайде. В настоящее время межгосударственный электронный документооборот осуществляется в тестовом режиме. До конца года планируется перевести его в продуктивный режим. Также сейчас ведется разработка актов, регулирующих взаимное признание электронных цифровых подписей при обеспечении трансграничного информационного обмена между бизнесом, B2B взаимодействия. А в ближайшем будущем также будут разработаны документы, касающиеся механизмов взаимодействия трансграничного пространства доверия Евразийского экономического союза со странами и объединениями, не входящими в союз. При этом в настоящий момент Евразийский экономический союз уже осуществляет информационное взаимодействие в электронном виде, например, с Вьетнамом. В целом можно сделать следующие выводы. Трансграничное пространство доверия еще не полностью сформировано на уровне отдельных международных объединений, тем более в мире. Но чтобы потом не переделывать многое, нужно уже сейчас продумывать способы взаимодействия между ними, так называемое S2S взаимодействие. Евразийская экономическая комиссия внимательно изучает существующий международный опыт с целью определения возможных способов взаимодействия трансграничного пространства доверия Евразийского союза с другими пространствами с учетом их специфики. Мы заинтересованы в создании условий для упрощения межгосударственной трансграничной безбумажной торговли с обеспечением достаточного уровня информационной безопасности. Основной задачей, которую нужно решить, это сделать юридически значимым электронный документ, подписанный электронно-цифровыми подписями в разных юрисдикциях. Также нельзя забывать о решении проблемы проверки полномочий лиц, подписавших электронный документ. В Евразийском экономическом союзе сейчас проходят горячие дискуссии на эту тему. Речь идет о необходимости создания единой системы проверки полномочий наряду с проверкой электронно-цифровой подписи. Я извиняюсь за то, что вряд ли смогу остаться на сессию вопросов и ответов, так как мне нужно участвовать в заседании рабочей группы, как раз посвященной взаимному признанию электронно-цифровой подписи при осуществлении межгосударственных, муниципальных и государственных закупок. Буду рад ответить на все вопросы. Контакты есть у организаторов, также сейчас будет представлен на слайде. В качестве заключения я хотел бы пожелать всем удачи в деле создания условий для упрощения международной трансграничной безбумажной торговли и снятия всех существующих барьеров. Спасибо за внимание.
Thank you very much, Yuri, for your interesting presentation. Actually, it's clear that you highlighted the importance of make it secure the critical infrastructure which is built by government. And it's clear also that these EU approaches are applied only for G2G information exchange. And taking this opportunity, I know that you will disconnect soon. I will ask the additional question to you. You said that you have you're already discussing with Vietnam and probably China and other partners of Eurasian Economic Union on information exchange. Do you think that they will agree to follow the regulation which is adopted in the EU? Do you think that EU will be more flexible for this type of exchange, or you will require other countries to follow this regulation? We are talking about the G2G now.
Да, действительно, с Китаем уже также прорабатываются вопросы по трансграничному информационному обмену, соответственно, вопросов доверенных сервисов. Что касается Европейского Союза, мы наблюдаем за реализацией, соответственно, этих вопросов в Союзе и пытаемся использовать технологии, которые в будущем смогут быть совместимыми.
So its interoperability is important for you as well. It's really good because this approaches, I saw that how many acts already are in place, and you said that it will be in the in production phase already by the end of this year. And I would like to say good luck with all of this work. I know it's not easy to promote, but it's really needed. And also, I know that there are some approaches already discussing how to arrange this schema for B2G information exchange and probably the B2B exchange in the future. Thank you very much, Yuri. Now we have a dialogue session, and we have a distinguished panel of speakers today who will bring rich experience and perspective from different regions and sectors. Let me introduce our discussant for today, Mr. Hiroshi Nakatake, Managing Director, Glyph, Japan, Luca Castellani, Legal Officer at UNCTRAL, Taksin Ahmad Khan, member of UNEXT Advisory Committee, former UNCFACT Vice Chair, and Vicky Manila, President of Cloud Signature Consortium, and she's also the Director of Trust Services at NTC Group. The first question I have for Hiroshi Nakatake. Hiroshi, could you give us an overview on how Japan has approached the development of trust services framework, and what other countries' experience you've studied and probably following? Hiroshi, the floor is yours. 5 minutes, please.
Sure. Now I would like to introduce the development process of the trust framework in Japan. A major point for our development of our trust framework was the late Prime Minister Shinzo Abe's declaration of the concept of DFFT, Data Free Flow with Trust, at the Davos Forum in 2019. And the idea is that the trust frameworks are most required in international transactions, and that is important to build a trust framework that can be used internationally. And based on this concept, we have been working on a project for international mutual recognition trust frameworks with Europe and India. And we are taking an approach that utilizes what we have learned from the project in building trust framework in Japan. So here is what we have been doing. First, we are trying to realize it by interpreting the trust framework by dividing it into a 3-layer structure. It consists of 3 layers. The infrastructure layer, first one, which includes the electronic signatures and electronic authentication. And then second one is the trust data distribution layer, which enables data exchange. And the third one is the trust application service layer, which makes trust data available to the business. So first of all, we have started to work on international mutual recognition with the European Commission, as EU has already eIDAS regulations. Actually, Mr. Navarro of DG Connect has been supporting our project. And in order to achieve the international mutual recognition, the first layer of infrastructure was further broken down into 4 component pillars and the comparison of the differences in each jurisdiction. For the third and fourth pillars in this chart, which are mainly technical verification, we set specific use cases and conducted POCs. And as a use cases, we exchanged CO2 emission data with an e-shell, digital shell with LEI, the legal entity identifier attached, and verified it with each other's trust framework. As a result of this verification, of course, some were common to each other and some were different from each other, but as a whole, we could verify successfully without major discrepancies. And based on the result of this demonstration, we created a demo video and showcased it at the G7 Digital Minister meeting held in Japan last year. And in addition, since India chaired the G20 presidency last year, so India has also joined these initiatives and continues to work on international mutual recognition based on a comparison of the 4 pillars, as I explained. And we are currently in the process of preparing a technical document of the result of the comparison in these 3 regions. which is currently in the final draft stage. Of course, even if India is added, we have found some differences, but we have not found any major issues in international mutual recognition. So finally, the considerations. Well, I would like to explain two main points that have been obtained based on these developments. The first one is that depending on the assurance level of the trust, the trust framework requires a legal arrangement that is internationally accepted to some extent, of course. This is exactly the same mechanism as possible as you imagine. And the other point is that the international mutual recognition that we are trying to achieve requires system or organization that continuously maintain the technical framework. So this is because it will be necessary to continuously update the technical aspect, and it will be necessary to continue to reflect updated technical aspect in a way that is legally consistent. So that is all of our approach to building a trust framework in Japan. So that's all from my side. Thank you.
Thank you, Hiroshi, for very concise and very informative comment on the experience of Japan. I think it's really interesting that you've provided this comparison, and I would be really happy to have this report from your side if you have some materials to share, because now we have discussing in the working group on Article 8 on cross-border mutual recognition, and we are doing this kind of assessment, what is going on in the world, and what are the schema for mutual recognition exist, and what you have done and what you have presented. It's a clear cases how country can be as flexible as possible to follow the regulation of EU if you need to have this information exchange with EU. So if you want to have exchange with the United States, you have another approach, but in common, as you said, it's more or less similar, right? So some differences exist, of course, but in common, they are really following one of the framework. And what's important now that's how to arrange and to make it more practical, right? So if you are following all the standards, so how to make it in as practical example. And actually, it's very interesting that I know that the European Union has this regulation more than 10 years, and the United States already applied this, and Japan also doing this, and it's quite a developed countries, right? And I would like to ask Mr. Castellani that we just heard about the practice of Eurasian Economic Union, European Commission, about the framework on mutual recognition. And of course, if they have a union and the high level of integration, the approaches for mutual recognition is also similar. But what should we do if there's not developed countries without any approaches exist, and but the willingness to have this information exchange is high? What should we do in this case? How UNCTRAL MLIT can support this kind of switch to paperless trade? Luca, the floor is yours.
Thank you, Alexei. A very good question. I would like, first of all, to thank you for inviting me, and also to thank the previous speakers. I was listening carefully to the extent that I could. Igor Furgel is, of course, the German delegate to the Working Group 4. He went on his technical knowledge, and of course, I'm a lawyer. I followed, yes, but some details may have got lost, not in translation, but in my limited understanding. I found it very, very interesting the fact that the European Commission now is focusing on cross-border recognition with non-EU member states, which was not the case under EIDAS 1, the one that was from 2014 to 2024, because the legal standard there was too high, and that standard has been a little bit relaxed. And I think that to work on qualified signatures and also on advanced signatures is an amazing development. Now, you asked me our solution, and I'm happy to talk about our solution, the model law on the use and cross-border recognition of identity management and trust services. I believe that a lot of the discussion that we had so far was a discussion on government-to-government recognition, and it was a discussion on creating trusted lists. And the creation of trusted lists take very significant amount of time, money, human resources, and efforts. The mandate of Ancestral focuses on commercial transactions. So we move from G2G to B2B. And in the commercial transactions, you have some legal principles which are very relevant, like, first of all, party autonomy that allows the people to choose whether we want to use electronic means and what kind of technology we want to use, and also what kind of authentication methods. But you have also principles which are in EIDAS, but for instance, I don't know if they are in all legislation. I doubt that, for instance, they are in Japanese law. EIDAS is built on technology neutrality, legal recognition, non-discrimination of trust services because they're not qualified. So EIDAS clearly says you cannot discriminate the legal effect of an electronic signature because it's not qualified. Which means that for B2B recognition, you can have simpler methods, not based on trusted lists, but based on eventually an assessment of reliability, for instance, by a court, which of course takes place only if there is an issue. And the truth is, in the commercial setting, we exchange, I would say, maybe billions of signatures every day, nationally and internationally. An extremely limited amount of them are actually challenged in court. Not to say that ancestral texts on top of that not only allow these what we call ex post, so after use reliability assessment, but they also contain a safety clause that says that it's not possible to challenge the reliability of a method that has in fact fulfilled its function, which means that we curb frivolous litigation and we curb repudiation problems. Because, you know, in many cases, the discussion on the reliability of the method used for a trust service for an electronic signature has to do with one party not wanting to fulfill its legal obligations and not about the fact that the signature was actually unreliable or that it did not fulfill its function. So I would like to conclude this short intervention, mindful of time, by saying, first of all, I very much encourage all countries, but especially countries that belong to the common law tradition, which is a bit less, you know, it has a bit less of form requirements, to consider the adoption of our model law on the use and cross-border recognition of identity management and trust services, where you will have really a range of options for cross-border recognition. You have also mutual recognition of trusted lists. You can build on that, as you said, Alexei. Not every region in the world has the political capital to have mechanisms like the EU or Eurasians, but you know, there are other ways of doing things. It's compatible with that, but you still have all these exposed, especially B2B mechanisms, which does solve a lot of problems in practice. So I think it's the best of both worlds. Thank you.
Thank you, Luca, for your interesting comment. And actually, I recently have read a new report from World Bank. It's discussing about the electronic signature, and they have provided really interesting research, what is going on in the world. And I saw this table, which clearly said that the level of reliability and the level of electronic signature should be used for information exchange. It depends on the risk. And there are like identifies 3 types of risk, and in each of the type of risk, you need to use a different. You can choose what kind of electronic signature should be used. I totally agree with you that most of the B2B transactions, they're like in the middle or even the low risk information exchange. So it can be used advanced electronic signature or a simple electronic signature without any questions. But the problem is that the government agencies, they do not accept this as evidence. So they still request a paper form, and the businesses, they don't want to follow this and to switch to the paperless trade just because of the government agencies they're requesting this. If the government agency would like allow them to use this and to accept this low and medium risk, it's okay. But as for the high risk, I think the businesses will want to use the qualified electronic signature because it's a high risk. They want to keep it secure, right?
Alexei, if I may, a 20-second comment on what you say. Think of this like you think of something that we do every day with government, which is payments. It is incredibly easy to send money to government. It is incredibly difficult to get money from government. So this is the assessment of the risk. Some transactions with government will not be high risk. Some transactions will be high risk, but we can all relate to payment. I think that's very easy.
Yeah. And also the motivation of the government agencies, as Yuri said, that we need to have a secure infrastructure. We need to make sure that no one will interrupt in our information exchange, and that's clearly understandable. So this G2G information exchange can follow this very strict regulation. But I agree with you that for B2B information exchange, there should be the way how to provide this more flexible way for information exchange and acceptance of this document. And what you rightly mentioned, that UNCTRAL MLIT has this kind of norms, and if it will be implemented within this national regulation, it will really improve the practice of using electronic documents for cross-border paperless trade. Thank you again. Now I'm switching to the next discussant, Mr. Han. Given your extensive experience at ESCAP, UNCFAC, how do you see trust services being implemented on the ground, particularly in the developing countries? And what are the main barriers in their adoption and how they can be overcome? Maxime, the floor is yours.
Okay, thank you, Alexei. I have a challenge that you have asked a few issues which definitely not only talks in terms of my country, but also talks in terms of what other developing countries have addressed till now and where they are struggling. And especially with respect to India and its neighbors is one aspect. The other aspects of Asia Pacific, and then at the UN-CFAC level globally. I will quickly go to 2-3 things. One, taking the discussion forward from where we stopped from Luca's discussion, that we do recognize that majority of the transactions in cross-border paperless trade, they don't require that level of sophistication in trust services integration. That majority of it, maybe 80% plus, do not need any kind of trust services integration, that it can flow. But rest of it, of course, if it is a financial transaction or other transactions, there it needs a respect and which need to be at the highest level. So I will quickly say what we did in India. We launched our e-commerce act in the year 2000. And then we decided that, and of course, it was conforming to UNCTRAL model law on electronic commerce. And we always felt that if it is so, and other nations in the Asia Pacific and globally, majority of them are following that UNCTRAL model law, then we will be interoperable. But that is not the beginning and end of the solutions. We did some issues at our end we did not address properly, that we did not integrate our act with the provisions which are very open-ended, in the sense that in the year 2000, digital signature was very prevalent, not the electronic signature. So we capsuled our e-commerce law with the digital signature provisions. And then we realized that, no, it is not very open-ended. Also, we realized that our act was not considering mutual recognition with the trading nations, because it was talking about what is going on internally within the country, because we are struggling to get something which addresses the requirement of the electronic transactions within the country, not outside the country. So we did in the year 2008 and 14 a tweaking on to our act, which integrates two things. One, that moving from digital signature to electronic signature, which is more open-ended in the sense that it doesn't call for much of harsh treatment on the document or the data which is to be shared. And also it provides different level of authentication depending on the kind of document it is. So that we did it. Then we realized that, of course, this trust services environment was slow in the sense that we need to develop something with the trading partners, because everything we were concentrating till then was within the country. So what we did, that we signed our first MOU with Korea to reach a level that we will respect each other's digitally signed documents. And that was first initiative. But we did not stop there, but we not only that we went to Korea, but we went to all our trading partner countries saying that let us sign an MOU for mutually recognizing each other's electronic digitally signed documents. But it didn't move forward. Therefore, we thought that we should take the help of any international institutions, that they should pilot this mutual recognition, that individually it will be very cumbersome for us to move forward. And that's how we came to, from there we moved to UN ESCAP, requesting them that there should be a mutual recognition arrangement under your umbrella. And they were very nice that they accepted this. And as you have mentioned in your initial submissions, that clause 8 of the framework agreement stipulates that mutual recognition is the necessity. And we started working there. And at the same time, you have asked the question how it is happening in Asia Pacific, especially with the developing nations. So ESCAP did a 4-nation study as to how the things are happening in these 4 countries. It was India and its neighbors like Nepal, Bhutan, Bangladesh, and that was the beginning. We realized that most of them have some level of trust services running, but it doesn't really addresses cross-border. It's only trying to address within the country. And in one of them is Bhutan, where there was no trust service. So we delivered a prescription that, look, those who do not have a trust service already in place, they can sign an MOU with India and use the trust services which are operating in India. And that is something which they said they will take it forward. But for remaining 2 countries like Bangladesh and Nepal, they said, yes, their act do not respect cross-border transactions, which will try to upgrade. And that is where we stand. That different level of preparedness are there, but it doesn't really address the things in totality. And that is where we stop. But if you see an example in Asia Pacific, that Pan-Asia Alliance is an alliance of about 7-8 countries in Asia Pacific, those who respect. This is an alliance between the service providers. Of course, government is not on the discussion table. So they very successfully did respect each other's digitally signed document in these 8 countries. But only thing which was deficient, that the government was not in the ambit. And I think that is a time that need to be added. Otherwise, it's a good example for somebody to take it forward. Similarly, you have said the European Economic Commission, Eurasian Economic Commission, the discussion we have seen today, and it flows from a white paper done at UN CFACT, respecting the initiative there and what should be the contours of this arrangement that should be taken care of. You have asked for the barrier. We find that that widely we recognize that the standards are required which are missing, especially with respect to the standards for running the trust services. harmonization of the rules of the game, which are missing in most of the places. So it's always necessary for us, for all the countries in the Asia Pacific, especially with respect to the developing countries, that ancestral model law to be adopted, and international standards done by institutions like ISO need to be adopted by the countries so that we can move forward. Thank you very much.
Thank you, Taksim, for your comprehensive overview of the national and international, especially in Asia, agenda on trust services, and also the obstacles you've mentioned. Actually, what we are trying to raise within our platform for discussion, and I see there's a lot of progress in India on trust service implementation, and for sure that you will be interested in this kind of discussion, and I hope that India will join the agreement soon and we can work more together. We'll see on that. And I have a last discussion, but not least, actually.
Can I get in here, Alexei, for 2 seconds?
Sure.
I missed one point that few of my colleagues from EEC is available here, especially a team of Dr. Sergey and those, that we are still in the process of doing a proof of concept between India and Russian Federation, that how the trust services can complement each other and how we can move forward. So those individual initiatives are already there and we are progressing very well. But I still feel that if this is taken care of within the ambit of the framework agreement, then perhaps it would be easier and fast to move forward. Thank you very much.
Thank you, Taksin. Indeed, there are so many initiatives and at the national level, and we are doing the kind of study right now to describe what is going on. And the case of Russian Federation and Belarus, Russian Federation and other countries is particularly interesting. Thank you very much. And we already touched the topic that the B2B information exchange is really important for cross-border paperless trade. But in case of SMEs, small and medium enterprises, most of the time they are out of the scope, and there should be a solution which will allow them to use these trust services without any problems at a reduced cost as well. And we were discussed with Vicky Manila about how to overcome this issue, how to make this possible for small and medium enterprises to use this trust services. And I would really happy to have your contribution to our webinar and to share your experience, how cloud signature can be used for this and to facilitate cross-border trade operation. Thank you. Thank you, Vicky.
Thank you. Thank you very much. Indeed, a very interesting conversation. Also in the chat, a lot of questions. I try to answer some of them. Just as a short introduction about Cloud Signature Consortium, who we are. We are a global nonprofit organization based in 2016 with the goal to provide a standard with an open source license for the most demanding requirements for generation cloud-based digital signatures according to EIDAS regulation. So that was the starting point, but we grew up and we managed in the end to develop specifications that can be implemented no matter the geographical region and no matter the regulatory requirements. And our members today are more than 78 companies, providers, governmental institutions, for which we have a special liaison agreement implementing these specifications in their services, being able to operate cross-border. And as a matter of fact, we discuss about the new European Digital Identity Framework and the wallet that will bring to the next level the possibility to generate signatures through digital identity wallet. Well, our specifications will be referenced and mandated through implementing acts for signing applications interacting with the wallet. But coming back to your question about small medium enterprises and how they can benefit, well, they don't care about the technology behind, they don't care about restrictions or requirements for trust service providers. They need to sign, and the signature is the very basic for talking about digital transactions and cross-border. So they need an application that can be used easily, that give them the possibility to sign instantly without further burns, needing to prove their identity in case of high-risk transactions that requires to have a very clear evidence of the identity of the signer. And we have seen on the market companies adopting, providers adopting our specifications and implementing, being able to give signing applications to customers that can use them instantly and without any further efforts, working seamlessly cross-border. So you can integrate in this type of signing applications providers that are based literally all over the world. So they don't necessarily have to be in EU. They can be also outside EU or in Asia. We have also had a big event this year in May in Japan. Trust Without Border was the name, where we discussed also and showcased implementations and real life scenarios where companies can benefit and governments can benefit from this. So I think the approach should be from a collaborative one. So government implementing digital services to their citizens must implement, must adopt standards that are widely used and recognized, to not go for solutions that can block them and would create silos of applications. On the other side, trust service providers must build their services based on internationally recognized and mature standards, and also standardization bodies should have a look on the market, on what is going on, what the people need, and how to make their life easier, because we know the technology allow us to have creative solutions, and those who design services must have as a North Star the consumer, the user, when they build their services. How to make something really simple, really intuitive, without the need to or guides on how to do that and what to do.
Thank you, Vicky. It's really interesting to hear that the business needs should be in the focus, right?
Yes.
So there is
this should be the North Star.
Yeah, recognition, but for electronic documents in B2B transactions, it should be easier and should be accessible for any kind of business. And actually, I wanted to have the second round of questions, but unfortunately, we are run of the time, and we have discussed a different approach, how to achieve mutual recognition, how to promote trust services and cross-border paperless trade. And as for my understanding, there are kind of two approaches. We are starting like from bottom up, bottom approach to down, to provide a set of regulations, standards, and other stuff to harmonizing approaches. And it's mostly done for G2G information exchange. And another approach is promoting, like Luca and many other experts. It's about the B2B information exchange based on more flexible solutions. And the issue is acceptance of these electronic documents and the trust services used by the businesses. And the last, we have around 5 minutes probably to wrap up a discussion, and I'd like to hear from you some last comments. What should be done by whom to really promote this agenda, and how we can achieve mutual recognition of trust services in the future? Dr. Furgil, please, probably start.
Thank you very much, Mr. Bondarenko. A very short story. 8 years ago, I signed off a B2B contract with advanced signature. And the counterpart of the contract called me the next day and told me I cannot accept it because I cannot verify your signature. So, and after this, I applied for this smart card. It's my qualified signature, and one week later, I signed it off with a qualified signature, and it was no problem with it. So it means it's a real situation. Also, the contract was only about 50,000 euro, nothing more. So that is why a lot of my experience is that a lot of, even in B2B environment, a lot of company requires qualified signature in order to have legal certainty. And our experience is that the way in this direction is to set up, first of all, a legal frame, for example, agreements about mutual recognitions. And then the countries should also set up, so each legal domain should set up an internal legal framework for the countries which follows ex ante approach. It means regulating in previous before a damage happened. And this regulation, this legal framework should address organizational and technical aspects, like technical standardization and, for example, such conformity assessments of trust service providers, or what the colleague from Russian Federation called trusted third party, something like this. It is a way, so starting with the legal level and then going more or less simultaneously diving in the technical standardization and organizational standardization. It is the way.
More or less the approach which is European Union created and they follow, right? Vincent, do you want to add something to what Mr. Fugger said?
I understand that the legal framework is always necessary in business and in gov-to-gov relationship. But for instance, the EIDAS legal framework establishes that electronic signatures will not be denied legal effects just because they are not qualified or they are in electronic form. That says that any kind of electronic signature could be accepted. What's the difference? The difference is the burden of the proof. Qualified electronic signatures by default must be presumed valid, while other electronic signatures, in case of dispute, the court will need to assess the evidences. That's the only difference. But I mean, some interventions may have pointed out to the establishment of a legal framework as something restrictive, and I don't share that opinion. It's the legal framework establishes the conditions for interaction, and this at least EIDAS is not very restrictive in this aspect. Any electronic signature is valid, unless or cannot deny legal effects just because it's not qualified.
Great. It's really good.
I can complement here a bit. Yes, definitely, I agree with what Vicente said. I think it's rather a question of market education and awareness, because most of the times these requirements are coming from legal department, for instance, or compliance departments that don't want to take risk to change what already has been in place for so many years. So going for the same path is more assured to them. Why change the requirements and implementing different services when it's working like that? And they need to be educated and to be explained and to understand that there is no difference and they can very easily and trusted use lower level of signatures than the most the highest one. Thank you.
Yeah, I totally agree with that, and especially, you know, the example of EIDAS is a very good example because EIDAS is a very balanced legislation. It is a matter of perception and it is a cultural problem, and the desire to stay with the existing processes and procedures. Also the desire to repeat paper-based processes and procedures in the electronic environment, you know, because there is a comfort zone. But I really think, I mean, not because Ancestral MLIT repeats EIDAS very closely, takes it up, but I think that that kind of what we call two-tier approach, so the one where you have trusted lists for G2G and those who want to go that way, and the other one where you have the ex-post assessment of reliability is the solution. We already have the solution here with us. We have all solutions, technical and legal. Well, the missing element is the cultural element and the educational element.
Absolutely. The capacity building it's what we're actually also doing at our level, to educate people. And this webinar, I hope it will also contribute to that. Taksin, please.
Thank you. I do believe that we have discussed and concluded that every document or data doesn't call for same level of respect from the angle of trusted services integration. Majority of it goes without this. B2B, I think one should not be bothered because it's a business driven, and majority of the time it doesn't call for that level of sophistication for this to happen for security and authentication. But of course, if it is G2B or B2 or G2G, then of course the government is very concerned about many of the things. So if the regulation accepts that it is up to the businesses to decide what kind of authentication which is needed, which should be good enough, then perhaps it moves. In our country, when we upgraded our provisions of security and authentication, trust services, we said if the regulator within the country is satisfied that a particular suggestion or the provisions are good enough to move forward, and if he feels that it induces the kind of comfort the trade and industry looks forward, he can still agree for this to move forward. And that is the best way to move forward. But definitely within the country, it is okay. But if it is between two nations or multiple nations, then perhaps the regulator of the different jurisdiction need to come to some understanding in respecting each other's documents which are electronically signed. And that is the way to move forward, rather than really not understanding that the technology moves faster than the regulations. So if we are not with the technology, then perhaps we are always lacking in the regulation part of it. So that is the best way, that a regulator should accept all kind of such issues and integrate into the work program. Thank you very much.
Thank you for your valuable comment. Hiroshi, would you like to add something, or we will wrap up?
I agree with the comments from the all panelists, but I don't think it's possible to solve all of these issues at once. So since legal frameworks are required, anyway, bilateral effort is necessary for each corridor. But I think the key is to set up an international organization.
Sorry, I can't hear you. Okay, so the efforts of international organization is required. Okay, great. So it also leads us to our closing remarks, which will be provided by my colleague from ESCAP, Ms. Soo-Hyun Kim. So the floor is yours to wrap up our discussion.
Okay, thank you very much, everyone. I think I can't do justice of summarizing all the rich discussions that we had in this 1.5 hour webinar. But we have heard from a number of cases and best practices, including the European Digital Identity Regulation, or EIDAS-2 from EU, which is built onto an integrated union, establishing an ecosystem ensuring legal and organizational coherence. We also heard from EAU's trusted third parties, also again focusing on trust and security ensuring for really establishing a secure environment for the countries. The Japan's experience was highlighting the importance of the international framework for mutual recognition, but I think he also touched upon the need for tailored approaches reflecting their unique legal and economic contexts. Luca has mentioned about the ancestral model laws, specifically on the use of the cross-border recognition of identity management and trust services. But along with that, all the model laws, which is built on the legal principles, allowing for, at least for B2B transactions, allowing simpler solutions not based on the trust services, but assessment of reliability. And we also heard from Tahsin, based on the India experiences and other Asia-Pacific developing countries, highlighting some of the limited capacities and infrastructures, and really not having the adequate capacities for the cross-border aspects especially. And we also heard about the very interesting aspect about how we can benefit SMEs, especially in their needs, meeting their needs for solutions with minimum requirements or simple or intuitive solutions for them for the digital credibility. So wrapping this all up, I think for me at least, my personal takeaways would be four. One is legal harmonization and technical interoperability that we have all talked about. The second one is capacity building and cultural shift is needed, as many of the speakers have mentioned. And then the third point is really when I was hearing all these diverse levels or diverse solutions of mutual recognitions, in a way, I think we need to acknowledge that the level of aspirations or capacities for mutual recognition is diverse. So the solutions are also diverse, and it could be a feasible approach to really acknowledge this diverse level of trust, and then also the solutions behind it. And fourth, and I would like to wrap up with this fourth conclusion, which is the importance of the international standards and cooperation. So this is very crucial for us as well, and we have been living and practicing it from ESCAP's perspective. As some of the speakers as well as the moderator has mentioned, we at the ESCAP, through the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific, it is a UN treaty fully dedicated to advance cross-border paperless trade in the region. And we have a dedicated working group on mutual recognition based on its Article 8. So building upon all these discussions that we heard from the webinar, we are really aspiring and we are really intending to bring this together at the intergovernmental platform to achieve some international, not international, but it is a regional, but we also go beyond the region. So this UN treaty dedicated would be a good platform for the Asia Pacific countries to join the discussions and moving the agenda forward in the region. So with this, I really want to thank all of our co-organizers, ADB, ICCDSI, and WCO. And I would like to mention that this is part of the webinar series on accelerating cross-border paperless trade facilitation, once again supported by the implementation of the Framework Agreement, or CPTA, the UN Treaty. So I would like to welcome and invite you all for the forthcoming webinar series. And thank you very much for all the speakers. And I also saw some of very active discussions and questions and answers in the Q&As as well. So very much thanks to the participants as well. Thank you.
Thank you very much, Sue, for your wrap up. No, but I think you did it really great. And I actually writing down what we should do in the next step to promote this agenda for our member states. Okay, thank you everyone for participating. Thank you for all of the questions in the Q&A. There are so many questions which is raised, and also I feel that we will contact and we can answer the question later on in the written form. Sorry, time is up every time so fast. So I'd like to say also thank to our interpreter to her excellent work, and we look forward to seeing you in the future session. Have a great day. Thank you.
Thank you.
Let's take a picture.
Bye.
Have a great day.
Speakers, please. Taksin, can you switch on the camera? I would like to take a snapshot. Okay, great.